Right, good morning class. Settle down, open your notebooks, and let's get completely focused. Today we're dissecting the perfect blueprint for answering a highly anticipated question on your family law paper. I'm talking about question 9, covering the various modes of talaq and their legal effects. I'm going to walk you through exactly how to structure your response to satisfy the KSLU evaluator and secure those maximum 16 marks. Pay close attention because we're breaking down the exact headings, statutes, and case laws you literally must reproduce on your answer script.
Here is your exact exam synopsis. 1. Meaning and essentials. 2. Approved modes. 3. Unapproved mode. 4. Other forms. 5. Legal effects. And 6. Conclusion. Your answer script must rigidly marry this exact 6-part structure if you want full marks.
Section 1.0. Meaning and essentials of talaq.
Now, before you even write out the definition, you've got to provide a strong, authoritative introduction. You must explicitly state to the evaluator that under Muslim law, marriage, or nikah, is a civil contract. It's not a sacrament, it's a civil contract, and therefore it can be dissolved in various ways. Only after establishing that fundamental premise should you write this definition verbatim. Talaq, the unilateral dissolution of marriage by the husband in accordance with Muslim law. Now, students, listen to me carefully here. I want you to heavily underline the word unilateral on your answer script. Doing this immediately captures the evaluator's attention. It shows you fundamentally understand the core legal mechanism of traditional talaq, that it proceeds from one side.
Following that definition, list the essentials. 1.1 Essentials of talaq. First, by a competent husband. Second, voluntary. And third, in accordance with recognized forms. These must always be written in distinct, separate bullet points on your exam. If you mash them into a single running paragraph, you will lose marks. The evaluators reward clarity, so lay it out clearly.
Section 2.0. Approved modes, or Talaq-ul-Sunnat. In your paper, note that these specific forms are recognized as the proper, valid, and traditionally encouraged methods under the law. Why? Because they leave room for reconciliation. First is 2.1, Talaq Ahsan, classified as the most proper form. The procedure is strict here. Step 1, a single pronouncement during tuhr, which is the period of purity. Step 2, this is followed by the Iddat period. Step 3, no cohabitation during Iddat. It becomes irrevocable only after the expiry of this period. You have to dissect for the examiner exactly why this is the most preferred form. It's because it remains completely revocable during the Iddat period. The husband has time to rethink things, making it the most reasonable mode.
Approximately 3 months. That's the statutory time frame for the Iddat period in this context. I strongly advise you to highlight or draw a circle around this duration in your exam paper. Showing precision with time frames proves you have a deep grasp of procedural family law.
Next up is 2.2 Talaq Ahsan, which is termed the proper form. Step 1, 3 pronouncements and 3 successive tahrs. Step 2, absolutely no cohabitation between these pronouncements. Step 3, irrevocable after the 3rd pronouncement. When you're writing this out, clearly contrast it with Hasan. The KSLU evaluator is looking for you to highlight that Hasan involves multiple pronouncements over successive periods, and crucially, it only achieves absolute irrevocability after that final 3rd pronouncement. Moving to Section 3.0, Unapproved Mode, or Talaq-ul-Biddat. Under 3.1 triple talaq or instant talaq, structure your answer exactly like this text comparison. Earlier position, instant and irrevocable upon 3 pronouncements in one sitting. Present position, void and unconstitutional. Look, illustrating this doctrinal shift from instant to unconstitutional is a massive mark-fetching milestone in your answer. Don't just state the current law, you must show the evolution.
All right, pens down for a moment. We've arrived at our first mandatory deep case law breakdown. Shira Bano v. Union of India. You absolutely cannot just name-drop this case. For a 16-mark answer, you have to break it down. What's the background? The facts involve a direct challenge to the constitutional validity of the practice of instant triple talaq. The ratio decidendi, the final verdict of the Supreme Court, is that they declared the practice of instant triple talaq strictly unconstitutional and void. So, what's the absolute relevance of this to our provision? Why does it matter? Because it fundamentally transformed Muslim personal law in India. It asserted that arbitrary, instant dissolution inherently violates fundamental rights, and it explicitly prioritized the protection of women's rights over unapproved customary practices. Exam tip for you. Command the evaluator's attention by drawing a distinct, neat box around this case name on your script.
Section 4.0,
Other recognized forms. Announce this heading clearly. For alternative forms, present it as form, definition, and legal effect. Talaq-ul-Sunnat. The power of talaq is delegated to the wife. The legal effect is a valid divorce when she exercises it. Iddat. The husband takes an oath to abstain from cohabitation. The legal effect, the marriage dissolves after a set time. Zihar. The husband compares his wife to a prohibited relation. Legal effect, the wife can seek judicial separation unless expiation is made. Listen, drawing this exact comparative table on your answer script is a brilliant time-saving exam strategy. It presents complex data beautifully.
Note this specific number, 4 months. This is the exact numerical time frame required for an ILA dissolution to take effect. If the husband abstains for 4 months after taking the oath, the dissolution triggers automatically. Do not miss this procedural detail. Precision like this is what separates an average student from a top ranker.
Section 5.0, Legal Effects of Talaq.
Detailing the aftermath is where so many students drop points. You must systematically address the rights, duties, and restrictions. 5.1 Key Legal Effects. 1. Dissolution of marriage. The marital tie officially ends. 2. The Iddat period. The wife must observe this waiting period primarily to ensure the legitimacy of any unborn children. 3. Maintenance. The wife is absolutely entitled to maintenance during the Iddat period. 4. Dower or mar. The wife is entitled to claim her unpaid dower. And 5. Remarriage. After an irrevocable talaq, remarriage is possible, though it requires halala in certain strict cases. By methodically listing these 5 outcomes, you're systematically mapping out the entire legal landscape following a dissolution.
And this brings us to our second mandatory case law breakdown, Mohad Ahmed Khan v. Shah Bano Begum. Pay close attention. The brief background of this monumental case revolves around a divorced Muslim woman seeking maintenance under the General Criminal Procedure Code, which sharply contrasted with personal law limitations of the time. The ratio dissidenti? The Supreme Court unequivocally upheld the right of a divorced Muslim woman to claim maintenance. The absolute relevance to our topic today is that this judgment powerfully reinforces modern welfare principles. It overrides strict traditional deprivations and ensures a divorced wife is not left destitute. Just like before, write this case law in a separate boxed format. Underline the case name to definitively capture the KSLU evaluator's eye.
Section 6.0, Conclusion and Judicial Trends. A strong conclusion based on modern judicial application is absolutely required to seal a top grade. You can't just abruptly stop writing after listing the legal effects. Your conclusion should reflect a 6.1 modern synthesis. Write these points down. There are now restrictions on arbitrary practices. There's an alignment of personal law with constitutional values. There is an emphasis on justice, equality, and fairness. And above all, the courts are prioritizing the protection of women's rights. You need to explain in your final paragraph exactly how the Supreme Court has successfully bridged traditional forms of dissolution with modern constitutional equality. I'll leave you with this final, provocative academic question to ponder as you finish your studies today. How successfully do modern judicial trends actually balance the traditional forms of talaq with the absolute constitutional values of justice and equality? Address that underlying tension in your conclusion, follow the exact blueprint we just discussed today, and you will undoubtedly deliver a perfect KSLU exam answer. Class dismissed.